Get started. I was waiting, Barry. I was dribbling out the clock for you. Well, good morning, everyone. Again, thank you for hanging in there with us on this first meeting. I promise you we'll get started right on the dot at all the rest of our meetings. But just want to say good morning to all of you. Really great to see so many familiar faces. As I told one of those familiar faces when I was walking in, I don't know what you did to be here, but I'm sure you deserved it. And I think that applies to everyone, not just you, Sean. I wouldn't single you out like that. But this is it's a powerful group. Got a lot of horsepower in here. I don't think we may not need all of it for the review of the county charter, but looking around this room, if we want to secede from the state of Florida or something, we may have the right group to do that. Let me clarify that it's not within your purview. Okay, that is it might sound like a good idea some days, but it's not within your purview. But let me look at my list here, folks. As in this on this committee, we have past county commissioners. We have a former city manager. We've got partners from our nonprofits, longtime partners from our nonprofits. We've got private legal counsel, real estate and development professionals, from banking, political professionals. Barry, whatever it is that you do, we've got that here.
Figured it out.
University officials. We also have church leaders, economic development leaders, county employees, elected officials, and that's just Darrell Jones. All right, so it occurred to me, though, that and I know all of you have interacted with Leon County over the years in different ways, in different capacities, but it occurred to me that you probably all have the same question this morning. And I'm going to go ahead and just get that right out of the way, right off the bat. That question, I'm sure, goes something like this. Vince, in my experience, Leon County is perfect in just about everything that it does. What could we possibly do here as a committee? Well, I'll get to that in just a minute. But first, again, let me introduce myself. My name is Vince Long. For those of you who I don't know, I know most of you, and we've been in a lot of the same orbits, but we're going to be very informal here. We're going to be spending a lot of time together, so please just call me Vince. Alternatively, you can use a nickname that, because we are informal, you can use a nickname that Mary Ann used to call me when she was on the county commission. It was a very sweet, kind nickname, kind of cute. She might share it with you if you ask her nicely. Conversely, I'd appreciate if you didn't ask Anita what the nickname was that she had for me when she was city manager. It wasn't quite as cute. Just kidding. They both had the same nickname for me over time. But hopefully, folks, what you get from my introduction here is that while you have important work to do on this committee, we don't plan to torture you. We think it's even possible that this could be an enjoyable and satisfying time for you. And let me just say that on a sincere note, that we really do appreciate you being here. We absolutely appreciate it. On behalf of the Board of County Commissioners, on behalf of our county employees, on behalf of the community, we appreciate your time and your insights. And before we go any further, let me maybe answer a couple of actual questions that you have right off the bat. First, let me say the obvious here, again, just to reemphasize. Your role here is very important to us. You'll hear us say throughout this process that the county charter is our home rule constitution. And a group like yours convenes only once every 8 years to make recommendations on potential charter amendments to the Board of County Commissioners to ensure that that county charter continues to reflect the needs and the preferences of our community. So that's why you're here. And again, and that's a very important role to us. Next, what all Charter Review Committee members want to know, what are our parameters? Let me give you your parameters. It's a long list because we saw the members on this group. So let me just tell you, you have very broad latitude. Let me be very clear about that. And the board was very specific about that. There's just one specific issue that the board identified, and that you have in your materials, that they wanted you to specifically, objectively review and make a recommendation to the board one way or another. And we'll get to that a little bit later in the process. But other than that, the board didn't limit your purview in any way or to any subject matter. You'll have 120 days to do your work. We've provided some bylaws so that you have productive, structured meetings. But as far as parameters go, that's about it. At the end, you may make significant proposed charter recommendations, or you may make none. But let me be very clear about this. That will be your decision. Again, you need to look, you only need to look around this room to tell this is not a rubber stamp committee. So again, broad latitude. And finally, let me just say that our role as county staff is to support you fully through this process. I staffed the initial charter drafting and led the referendum back in 2002. And I've conducted, along with county staff, the Charter Review Committee processes, the two that took place prior to this one over the last 25 years. So along with the county attorney, Chastity Osteen, who you'll meet here in just a moment, who brings a tremendous amount of insight and knowledge into these issues. If you can stump Chastity with a legal question, you'll be the first one to do it. Or maybe that's just me, Chastity. But together, again, we take a lot of pride in staffing you all so that you have all the information that you're going to need to make the very best decisions that you can along the way. So let me see what else we have here. In addition to, and this is the most importantly, in addition to myself and Chastity, we have a resource team here from the county that's going to walk you through this process every step of the way. And you'll hear me say that quite a bit, every step of the way. It's going to be very methodical. You're going to review every article of the in section of the county charter, and you're going to be able to weigh in on all of those. But our team, first of all, Ken Morse, right here behind me. He's not my little brother, even though people tend to think so sometimes. Ken's our assistant county administrator, brings a wealth of knowledge to the process over 20 years across all aspects of county government. Nikki Hatch, Nikki, there you are. Nikki is our point person for legislative and intergovernmental affairs at the county. She's also your point person in this process. She has extensive experience at the county, including helping to staff our last charter review effort in 2018. Again, Nikki will be your primary staff person. And Cameron Williams. Cameron, can you wave your hands wherever Cameron's at? There he is back there. Cameron is our superstar policy analyst who you'll also be engaging with throughout this process. So again, there's your team, folks. Real quick today for the meeting agenda, let me just say that, again, today, as you know, is an orientation. We're going to do a review, an overview, rather, of Charter County government. Importantly, you're going to have a presentation on open government laws, very important, from Chastity Osteen. Nikki and Ken are going to walk us through the bylaws and the schedule for meetings. Again, so we've got quite a lot to cover today. So before we get started, let us just go around the room quickly here and give you guys the opportunity, give you all the opportunity to introduce yourselves. So again, just very quick, because we have a lot to do. I say quick because you do have elected officials on your committee. So if Chauncey, if you want, no, actually, I almost called you Ed. Can you believe that, Slayton? I'm sorry. So Slayton Murray, if you could start us off. So just real quick, your name maybe a little bit about what you bring to the committee. And if you have nothing else that you want to say, your most embarrassing moment, that'll be fine. You can just go ahead and do that. So Slayton, you want to get us started?
Thank you, Vince. Slayton Murray, born and raised here in Tallahassee, Florida. I'm with NAI Talcor here in Tallahassee. On top of just real estate, I also serve as the chair for the Downtown Improvement Authority and also serve on the DRC, so the Downtown Community Redevelopment Agency. Thank you.
Thank you so much, Mr. County Administrator Vince. My name is Chauncey Haynes, and I work with the Leon County At-Large County Commissioner Carolyn Cummings, and I'm just happy to be here this morning with such an august group for undertaking we only do every 8 years. Thank you so much.
Mr. Administrator, Vince, Sean Pittman, I'm here. I don't know why I'm here. I figured I'd find out pretty soon, but I run a law firm that primarily practices in local government law, so happy to be here.
Good morning, County Administrator Vince and colleagues. I am Daryl Jones. I am the Deputy Director for the Office of Economic Vitality for Minority Women and Small Business Enterprise Programs and a member of the Leon County School Board representing District 3.
Good morning, everyone. I'm Anita Favors, and I am retired from the city of Tallahassee.
You don't have to sound so happy.
God is good. I was there I've been in Tallahassee 35 years now. Did not come with the idea that I would be here nearly this long, and thought that I might leave after I retired, but this is my home. I love Tallahassee. I'm very honored to be a part of this group.
Good morning, everyone. My name is Linda Bond Edwards. I am an attorney and I've represented state and local governments throughout my career. I've represented elected officials across the state, and I hope that helps me in this process. I currently, however, am a mediator and an arbitrator, so I've left the litigation world behind, and hopefully those dispute resolution skills will come into play in this process. I'm glad to be here. I've been in Tallahassee for 33 years. I came here to attend law school at Florida State. So like Ms. Favors, didn't plan to stay here, but I'm thankful to be here. And I think Tallahassee is a wonderful place to live.
Congratulations on leaving litigation. Good morning, I'm Liz Ellis. I'm a shareholder at Stearns Weaver Miller. I currently practice solely civil litigation. In my current capacity, I'm pretty adverse to local governments, but in a past life, I represented only local governments. So hopefully that will assist me in this work. Looking forward to it.
Still morning? Yeah, about 5 minutes. Good morning, I'm Barry Wilcox. I am the Director of Land Use Planning and Development for Stearns Weaver Miller. I work with Liz, and we rode over here today. I'll blame it on her.
It was Barry's fault.
It was Liz's fault completely. Eddie, I was previous growth management director for Mr. Vince Long, Leon County.
If you didn't say it, I was going to ask.
I was getting. I'm a city planner, you might have guessed, and but about 25 years of experience, and I've been here in Tallahassee for 10 years. Love Tallahassee, raised my kids here. We moved up from Orlando, and I tell people going back to Orlando is like going back to an abusive relationship. I don't know why I spent all that time there. So very happy to be here.
Hey everyone, Max Hurley. I've spent my career as a consultant, and I've made the crazy decision to now be a candidate for Tallahassee City Commission seat 3. I am a native here and a lover of Leon County and City Tallahassee history, which is why I'm so honored to be here in one of certainly our community's largest legislative bodies ever impaneled. And so I want to thank the Board of County Commissioners for having the wisdom to appoint all 21 of us. Thank you all.
Hello, everyone. My name is Bruce Struble. I am a 25-year citizen in Tallahassee, Florida. I currently work with Florida A&M University as a professor of political science, and I also work with the local nonprofit called Citizens for a Sustainable Future. Very happy to be here. I'm really passionate about environmental justice and human rights, so I hope to bring that perspective to this committee.
Good morning, everyone. I am Joey Davis. I grew up and born and raised here in Tallahassee area. I've been involved in labor relations and in emergency medical and fire services for the past 20 years here in the area, and I currently serve here locally as a lieutenant firefighter paramedic.
Good morning. I'm Dr. Temple Robinson. I am the CEO at Bond Community Health Center, one of the federally qualified health centers here in Tallahassee. Joey and I have worked together in the past on the front line and have done good works. I was appointed by Commissioner Proctor, and I'm proud to serve. I also serve on the Economic Leadership Vitality Council for the city, and happy to do the little bit that I can here.
Good morning, Katrina Tuggerson, Capital City Chamber of Commerce. I'm here because I serve in the community and care. I am also an assistant to Daryl Jones. With what all the things that he does, I'm always right beside him and a lot of you around this table, so it's good to be with you this morning.
Good morning, I'm Jay Terry, Florida State University and president of the 100 Black Men of Tallahassee. I'm here because I have a background in aligning education, specifically post-secondary education, with the needs of the community. Very happy to be here and appreciative that, again, Mr. Proctor appointed me. Thank you.
I have no idea what nickname you were talking about.
I do.
You're not fooling anyone, Mary Ann.
Whatever. I'm Mary Ann Lindley. I did serve on the Leon County Commission for 8 years. And it's like a family reunion here, being with so many people I worked with and know all of you from so many different places too. I was a journalist for many, many years before that. I came to Florida right out of college, like so many of you, thinking, well, let's see what Florida's like, and would stay a little while, but I've ended up here all these years later, so it's a real pleasure to work with everybody. Thank you.
Thanks for having us, County Administrator. I'm Ryan Ray. I'm born and raised in Florida, lived in Tallahassee for about 12 years. I work as an aide to City Commissioner Jeremy Matlow across the street, and chair as the Leon County Democratic Party local government enthusiast. So a pleasure to be serving with all of y'all.
Good. Howard Kessler, retired orthopedic surgeon, recovering county commissioner from McCullough County. Worked as a teacher and, of course, the orthopedic surgeon. And I consider myself a civically concerned person, and that's why I'm here.
Good morning. I'm Henry Lewis. I'm the chairman and CEO of Retirement LLC. That stands for Living Life Completely. But prior to assuming that position, I was dean of the College of Pharmacy here at FAMU for about 18 years, interim president and former county commissioner. In fact, this facility that we sit in today is the first permanent home of the county library prior to moving from where the police station is going to be next. And it is located in District 1, what I represented at the time we built it. And now the dean of the county commission represents Bill Proctor. So I'm glad to be here as well.
Well, good to follow because I'm a proud graduate of the College of Pharmacy with my doctorate in public health. I'm Dr. Shamario Robertson. I previously served as the Deputy Secretary for the Department of Health for the state of Florida during the pandemic. I now own my own consulting firm. We focus on management and consulting with a focus on health and human services, DSR, and then we also have a nonprofit arm, DSR Public Health Foundation, where we focus in large part on rural health and minority communities and underserved populations. In addition to that, I own Classic Cleaning Professionals, which is a cleaning company here in town where we're working to bring high-wage jobs to other people in the community. And I am happy to serve here and want to bring my experience as an epidemiologist to the community.
Great. Well, I told you guys about the horsepower in this committee. Clearly, Wasn't joking around. So I also noticed too that two commissioners joined us, Commissioner Minor and Commissioner Proctor. I would ask them to say a couple words, but we only have to 1:30. As you guys know, no, let me do that right now. Let me just go off script. Anything that either of the two of you would like to, while we've got the committee here, this is the highest amount of attendance we'll ever have. It's the first meeting. So go ahead, please. The Dean of the Commission, Commissioner Proctor.
Good morning, ladies and gentlemen. We thank you for your willingness to be a part of this democratic process, the gumbo making process that undergirds public policy making, which in this community, each of you, as I listen and understand the roles that you play, you all are process-oriented people. And in a moment like this, the one that we're existing, I am so glad to see the diverse, the rich minds, and the talent at the table. I hope that y'all bang heads hard and clash. That's what democracy is about. And understanding is something that just doesn't come easy. It often, you have to wrangle for it, and for your willingness to do that for a brief period to undergird the strength of this community. I say thank you, and we thank you very much.
Commissioner Proctor, Commissioner Weiner.
Now, do you see what happened there? I made the mistake of going after a preacher. Listen, I wanted to thank everybody for being here, just being in this room and seeing all of you assembled together for the first time. It's really exciting. I'm going to steal a line from an elected official that's very well known from the Gettysburg Address. He said, government of the people, by the people, for the people. Leon County is a representation of that. And you being here is a strong symbol of us maintaining that commitment to a democracy of the people, by the people, for the people. So thank you very much for what you're doing. You are doing a very important public service. And it's a solemn duty, but as Vince said, you guys are going to have a lot of fun. Very grateful to have you all here. Looking forward to hearing what you all come up with over the next several weeks. And anything that we can do to help you, let us know. Thank you all very much.
Okay, so everybody ready?
Ready.
You ready to go? All right, I told you this is orientation day. We're gonna throw a lot at you. It starts off with an overview of Charter County government, folks. Let me just say that this presentation is under tab 6 in your books. It also has room for notes, although you may not want to write anything until you hear from Chastity. I don't know. Or at least be very careful about what you write, right, Chastity? So again, as a professor of mine used to say years ago, at the end of this presentation, at a minimum, you're going to be confused at a higher level. So that's something, right? And I need to, and again, let me assure you, you're going to be going through a step-by-step process here. So this is all background, just to kind of get us all on the same page. A broad overview, again, to get the ball rolling. I have to admit, you'll never be able to tell this by today's presentation. I taught at FSU for about 15 years in the graduate program in the MPA school. And to date myself, over 20 years ago, Ken Morris was a student in that class. And he could tell you I had a very embarrassing moment one time in that class in the middle of my Charter County government lecture. Somebody fell asleep. It was very embarrassing because that person was me. I was giving the lecture. So I will tell you this, folks, this is the movie trailer version of Charter County government. I'm going to be going quickly. So hang on, save your questions to the end if you could. And again, you've got the opportunity to take some notes down there. So what is a county charter? Again, we're going to start at the beginning. Like I mentioned to you, and again, I realize that most of you know a lot of this, but just to get, again, that base level of information in the room, it is our home rule constitution. It establishes the framework and then the broad structure of county government, our organization, our authority. It is a living document, folks, and the most important thing that I'll say is that it can only be approved and amended by the local electorate. So why county charter county government? Quite simply, it's born out of the idea that for local governments, one size does not fit all. There are no two counties in Florida that are identical. Man, is that not an understatement? Go ahead, feel free to insert your Florida man joke here. But Miami-Dade and Wakulla County, what do the two have in common, Dr. Kessler? Well, they're both charter counties, for example. That may be the only thing, but while all counties have the same general purpose and the same required state mandates to carry out, they all have very unique local issues to address. And the problem with that historically in Florida is that county governments are established much differently than cities, for example. Cities all have charters, again, which are their home rule constitutions that specify and lay out their structure and power and authority. Historically, and this is an important point, counties, and people, not everybody makes this distinction, but counties were created originally very differently than that. Originally, counties were created to decentralize state government. Back in the 1800s, for the most part, the county was geographically divided to carry out skeletal state functions of that time in, I might add, a rural and sparsely populated state of Florida. And again, over time, this top-down structure in Florida became obviously very, very limited in meeting the needs and reflecting the needs and preferences of people who lived in counties because, as we all know, with the popularity of the automobile and the construction of the state highway system, the advent of the suburbs and handsome county administrators, county government evolved very quickly into modern local governments, right? Full-service local governments, and charters enabled local county governments to address local issues, to realize their full home rule power or their powers of self-government. We'll be talking much more about that in future slides. And importantly, the ability, again, to adopt a county charter. And I'll talk a little bit about that. But before we talk too much about home rule, speaking of handsome guys, let's talk about what predated home rule just for a moment, because I think it provides important context. So prior to home rule in Florida, and in the country for that matter, local governments were governed by what is known as Dillon's Rule. And John Dillon was an Iowa State Supreme Court justice who had a famous 1868 ruling that became the law of the land at the time, and for about 100 years in the state of Florida, and actually for most of the country. And it said that local governments only have those powers that are expressly granted by the legislature. And when he said expressly granted by the legislature, he meant it, as in explicitly granted verbatim in terms of the specific powers that counties could carry out, and that local governments at the time, all local governments could carry out. And he said, and I love this quote from his ruling, and I've talked about this quote for 20 years, but he said that municipalities were, quote, mere, I don't know why Chauncey he had to say mere, but he said mere tenants at the will of the legislature. Again, we're just paying rent. So he was a big state preeminence guy, to say the least, right? Matter of fact, he could probably get elected to the state legislature today, Commissioner Proctor. I'll try to. I'll try to behave. But again, this was the law of the land for about 100 years in Florida into 1968. The 1968 Florida constitutional revisions, which granted home rule power to local governments and to counties, and the ability, specifically the ability of counties to pass a county charter. Interestingly, though, a few states, very few states, still operate under Dillon's Rule today. Just to provide a little glimpse of what that looked like, again, prior to home rule, because it will be, again, important context for you all. But prior to 1968, the Florida legislature, under Dillon's Rule, and under an 1868 Florida Constitution at that time, which again was established for a rural, sparsely populated state of Florida, the legislature was overwhelmed in the time between, let's say, 1868 and 1968. And at that time, operating under that explicit requirement of language, and otherwise without such language that articulated the authority of county governments and local governments, you were presumed powerless. Local governments presumed powerless to act. So in, for example, 1965, there were 2,107 local bills filed in the legislature. If you look back just to last legislative session, there were 35 local bills filed. So if you needed, as a county government, if you needed to put up a traffic signal, or if you wanted to open a county library, for example, you needed express permission in statute from the state of Florida to do so. Side note, Sean Pittman says, that sounds like pretty good business there, Sean. 2,100 local bills, you could have handled that, right? But again, rather than engage in comprehensive local government reform in the 1960s, the state of Florida decided to do something different. They said, rather than try to contemplate all the needs of all the counties across the state of Florida, we are going to simply advance a constitutional amendment to the voters of Florida to allow them and authorize them to pass, for the voters of any county to pass a county charter, which again would be their constitution, provide broad home rule, and give them the flexibility to address local issues. Importantly, each charter, again, had to provide a mechanism, which brings it right back to you, a mechanism for citizens to review that charter over time as provided in that charter. We'll talk more about that in a moment. A quick glimpse of charter county governments in Florida. We'll also have a comparison for you all. We have a comparison in your binders, and during this process, we'll go over a comparison of the provisions of other charter county governments. But since 1968, 20 counties have become charter counties. That's a minority, obviously, of the total number of counties, but it represents about 75 to 80% of the state's population. Also, again, Dr. Kessler, Wakulla County is the most recent charter county, the citizens having passed that charter in 2008. The most recent attempt to pass a charter was a citizen-led petition drive in Manatee County in 2018, but there was not enough signatures to get it on the ballot. Two ways for a charter to get onto the ballot. We'll talk a little bit about that too. One is by the county commission placing a charter on the ballot. The other is citizen petition initiative. They're placed on the ballot by county commissions. Okay, that brings us to Leon County. Again, I said I would go quickly here. In 2002, Leon County passed our charter. We called it a starter charter. That's not uncommon for new county charters. And what that basically means is that when a county passes a charter, that starter charter usually simply articulates and codifies and memorializes the structure of government that's in place at that time. Understanding, again, that a charter is a living document and it will be amended over time. So, and major provisions in that charter, again, it reflected that 2002 charter reflected the organization of the county government at the time as a council manager form of government. We had a council manager form of government prior to this, but again, that first charter codified that. It has a provision in them that recognizes the roles and responsibilities of the county constitutional officers. Let me pause on that one for a minute, because this is interesting. Back in 2002, and prior to that, one of the big reasons that many counties established charters, it was among the top reasons that you would see for many years, was the ability of counties to change the elected status and the function of constitutional officers, so long as their statutory duties were provided for. So I will fast forward, even though our starter charter reflected that at the time, which was to not do that, the understanding was over time you could. So if you didn't want to have an appointed or an elected sheriff, for example, you could have an appointed director of public safety, for instance. In 2018, the Florida legislature advanced a constitutional amendment in Florida which negates that provision. And it basically says that you cannot change the structure and authority or elected status of a constitutional officer. Now, there are things that I could say in my class, because of academic freedom and that sort of thing, but this is kind of fun to get me back on my soapbox from those days. Look, I love our constitutional officers. And again, this is just a side note. It's a moot point. The Florida Constitution has been changed. You cannot change the elected status or function, even through a county charter of constitutional officers. But I used to have a lot of fun with this in class, because I'd say, well, of course, you have the ability to have greater efficiencies. if you were to change the elected status or the function of a constitutional officers. None of our constitutional officers have policymaking power, yet they're elected. They have huge budgets. Again, they're all buying pencils for different amounts of money. And that you have to understand, we're one of very few, we're one of 2 states in the country that have an elected supervisor of elections. And so all of those questions were good questions at the time, and only a few counties ever did amend and create different structures for constitutional officers at the time. But again, I point that out because you could have. When I was in class with students, I used to have fun and say, which again was very true. I said, when you elected your tax collector in the 1800s, you elected the person with the best horse because they could get to all the properties and they might have had relationships with the most people. But again, you could question, and you had the authority over that time to question, and some counties did, and they would bring in, and if you need only drive to Georgia and realize that the supervisor elections function is within governments and professional property appraisers go to college and they get a master's degree and they appraise, but it's an administrative function. And so, but in the state of Florida, no can do. Just interesting, that's all. And so, again, also, as in any charter, that starter charter in Leon County has a charter amendment process. Let me talk just briefly about that, because I'm going to get on to the revisions that were made in 2010 and also in 2018. But before I do that, just to hit very quickly, charter amendment processes. How can you amend a county charter? Again, county charters can only be amended and changes, amendments only approved by a vote of the local electorate. There are 3 ways that issues can get onto the ballot. One way is through a citizen petition. This requires signatures from 10% of the local electorate, and that must reflect 10% in each commission district. And that can happen anytime. So citizens can create a citizen petition to amend the county charter. That can happen anytime, so long as it goes to a general election ballot. That has never been exercised in Leon County. Also, charter amendments can be advanced by the county commission. The county commission, it requires a vote of a majority plus 1 of the Board of County Commissioners. That can be done at any time as well. And again, since there's always a lot of talk, and I've helped out with county charters in other counties across the state. And it's funny because especially when anyone's passing a new county charter, they're all very worried that the citizen petition initiative and even the county's county commission's ability to change the charter, they spend days on making sure those thresholds are high enough because they don't want folks willy-nilly, changing the charter. It's just kind of funny that generally speaking, those 2 initiatives generally aren't utilized. What is utilized is the third one, which again brings us to us, which is every 8 years in the Leon County Charter, we convene a citizen committee to review and make recommendations. So let's talk about real quick the last 2 efforts. And again, I know I'm moving quick. In 2010, again, the charter passed in 2002. In 2010, we convened a committee like this, not as good looking, Anita, but a committee just like this, a little bit smaller. And they advanced 7 proposed amendments to the Board of County Commissioners. And I'm going to just walk through this real quick because I think it's going to be instructive when you all start considering what charter amendments you may want to consider. And so the first one there is the tourism development structure, or county tourism. So the committee at that time in 2010 recognized that some organizational structural issues had changed from 2002 to 2010. And in this case, the county had taken over the tourism function. So again, they made a recommendation to amend the charter to reflect that. Minimum countywide standards. I talked about this. Again, you're going to talk more about this. We're going to have a specific agenda item, if you will, for you all to discuss this. But charters allow for the ability to clarify where city and county charters conflict, or city and county ordinances rather conflict, which ordinance prevails to the extent that they conflict. So while that first charter didn't do anything, like I mentioned, it just simply said, hey, municipal ordinances are affecting the city, county ordinances are affecting the county. In 2010, the Charter Review Committee advanced an amendment to the Board of County Commissioners to have countywide minimum standards for environmental regulations. As Anita could talk a lot about at the time, there was a lot of talk about stormwater not recognizing political boundaries, and why should it, and that kind of thing. And so I'll talk about that more in a minute. The appointment of the county administrator, this was to require a majority plus one vote to hire or fire the county administrator. I put that one in there. No, I didn't put that one in there. This was done, you guys will review lots of charters, and this was one that the committee reviewed and recommended. They'd seen in other charters, and it's actually referred to as the Midnight Massacre provision. And again, commonly known, so that it requires, again, a majority plus one, and that a motion to fire the county administrator has to take place at 2 successive commission meetings, kind of a cooling off period sort of thing. Considered a good government thing. It's great if you love the county administrator. It stinks if you don't. But again, anyway, it's one of those things that was included or was recommended by the committee to the county commission at the time. Similarly, non-interference policy. Again, a non-interference policy, folks, prohibits the Board of County Commissioners from interfering with the performance of the duties of county staff. It's very common. You see it in most county charters. You see it in most city charters, if not all. This is something that existed in policy before we had a charter, but this was an issue, again, in comparing other charters. The Charter Review Committee at the time wanted included in our charter, and they recommended that to the Board of County Commissioners. The other thing here, very quickly, campaign contributions. The committee heard a lot from local citizens who came to address the committee. You all will hear the same from citizens, different issues. But at the time, there was a move to have minimum campaign contributions be $250 per person per election. And they advanced that. I'm going to tell you the outcome of all these as well. But they advanced that to the county commission. I just want to explain what the amendments were. 6 was petition thresholds. They wanted to reduce the number, this is the committee, they wanted to reduce the number of signatures required to propose county ordinances or county charter amendments from 10% to 7%, and 5% in each of the commission districts. The committee believed at the time that the bar was simply just too high. They wanted to lower that. They recommended that to the Board of County Commissioners. And the final one, the future charter review committees. This is something that a past committee was thinking about you guys. And they said, hey, we want an amendment that says that will require that proposed charter amendments approved by a 4/5 vote of this board not go to the county commission, but go directly on the ballot. What do you think about that? So you guys are going to get drunk with power here very soon. No. But anyway, let me tell you what happened with all these amendments. So actually, before I do that, let me go to 18. 18, fewer amendments proposed to the Board of County Commissioners by that committee. 2, they wanted the board to adopt by ordinance a code of ethics, and they also wanted a provision for the county attorney that looked like the previous provision for the county administrator. In 2010, let me hit these real quick. 6 of the 7 amendments recommended by the CRC to the board were placed on the general election ballot. The board did not accept the proposal to advance CRC recommendations directly to the ballot. That's the one that the board did not place on the ballot. 5 of the 6 amendments on the 2010 ballots passed. Voters chose not to reduce the petition threshold for citizens, interestingly. In 2018, just one of the 2 amendments were placed on the ballot by the board, the code of ethics requirement, which was approved by the voters, and the board did not advance the proposed modifications on the employment of the county attorney to the ballot, but instead did that by ordinance. I say all that to say there's a lot that's in there that is instructive to you about maybe things to think about when you're considering proposed charter amendments as well. Let me run through just a couple of those. And you saw that logic sort of reflected in several of the charter amendments that I just talked about. So first of all, very high level, not every local government issue is a charter issue. Many of the workings of local government can and should potentially be handled in other ways, such as by by policy or by ordinance. So like the county attorney employment modifications, the board ultimately determined that we have the ability to do that by ordinance. Why put it in the charter? Let's just do it. And the board took it up and passed it and did it by ordinance in that case. Also, existing authority of the Board of County Commissioners. There's a lot of issues, and you all will probably have deliberations where you talk about things and you decide, hey, why put it in the charter? The board should just do it now. They should either do it now, or there may be the case that you take a look at an issue and say, the board's chewed on that issue and decided not to do it. And then you'll have to decide, do we want to propose it as an amendment or not? And in other cases, you'll find that the state legislature either plans to address an issue, or you may determine that it may be more appropriate at the state to do it, such as the campaign contribution issue. Again, our voters, we put it on the ballot and our board has approved the $250 limit on campaign contributions. But in 2021, the state legislature came and made it a statewide contribution limit. Again, we couldn't have known that at the time, but it's just some things to consider. So what can the charter do? And again, I just got a last few slides here in terms of throwing all this against the wall at you. So what can charters change and do as indicated on the slide? So first of all, like I said, they can alter the structure of government. They can expand or restrict countywide authority. When I talk about structure of government, folks, too, when we go through the county charter, we'll go through the division of responsibilities on the executive and the legislative function. Again, they can expand or restrict countywide authority. That goes back to that issue of ordinances. Again, you'll have that issue specifically agended for you. Electoral representation. We have 5 district commissioners, 2 at-large commissioners. Charters can change that. Charters can say, maybe there's a better balance. Maybe it should be, 3 district commissioners and 4. Again, that's all fair game. And then clarifying and removing outdated or confusing charter language, that sort of thing. Things that can't fit, this is obvious to everybody, but it's not a quick fix for a recent problem. It doesn't decrease crime or jumpstart the local economy. It doesn't stop a controversial project necessarily, unless there are larger structural elements that play in. And again, it doesn't necessarily mean that it'll make everyone play nice together, even though that's a nice objective. Bringing it in for a landing, folks, here. As I mentioned earlier a couple times now, the board did not wish to limit your purview, and you've got broad latitude in considering charter amendments. Like I mentioned, again, you've got 120 days. We're going to walk you through each article and each section of the county charter. You'll be able to consider that, ideas that you receive from the community, ideas that this group has. One issue that the board did, however, direct the committee to objectively review and consider whether or not to advance as a charter amendment is on the screen, and that is to provide that county ordinances prevail when there is a conflict with city ordinance, except when restricted by state law. And I'm sure Chastity will have a lot more to say about that. But again, I put that in here, first meeting, high level, only issue that the board said we'd like the Charter Review Committee to look at that one and make a recommendation. And again, you'll have the opportunity to look at that with all the information, and that'll be all staffed up for you. Finally, folks, I want to leave you with a few do's and don'ts to keep in mind. It's important, Chauncey, not to get these two lists mixed up. Don't do the don'ts and not do the do's, okay? So again, before I go into that, again, reviewing and potentially amending the county charter, obviously, folks, is a major task, long-lasting impacts for many years to come. So we just a few do's and don'ts to leave with you. Be a team player. Be cautious about making, I would say this is always a good one, be cautious about making premature statements on issues that you'll be deliberating. That's just good advice. You may change your mind 6 times before it's all over. And so be cautious about that. Try to think beyond special interests and the politics of the day, because ultimately any proposal that you advance to the board and that the board places on the ballot must have broad support from the community. Folks, we covered a lot today. Again, I know that that was a lot and it was quick. It was just, a couple hundred years of history and everything that's ever happened on the Leon County Charter since 2002. But I appreciate your patience, appreciate the opportunity just to sort of get all that out there as a starting point. I know that up next, we've got our county attorney, Chastity Osteen. But let me do this. I'm okay with stopping. If you want to just put that up, Nikki, I'm okay with just stopping for a minute. If anyone had any burning questions that you'd like to ask, I'd be happy to answer any of them based on that presentation. Nothing good. All right. Okay, Mary Ann.
Well, no, I mean, anything about maybe the county attorney's going to speak to us speaking to each other off campus, being private on this, or is there any?
What a wonderful segue.
About that.
What a wonderful segue. That's exactly what the county attorney is coming up here to talk about. So anyway, thanks, folks. Our county attorney, Chastity Osteen. Thank you.
We are officially into the afternoon, and we don't have that much time left, I know. I'm going to try to be brief. My name is Chastity Osteen. I know and have worked with some of you, not all of you. I look forward to working with you as you conduct your work on this committee. Before I start, can I get a show of hands on those of you who have had prior training or experience with Sunshine Law, Public Records, Code of Ethics? I figured most of you would. Okay, good. And we'll also cover public statements, including social media as well, okay? So, jumping right in. Sunshine Law, why do we have it and when does it apply? Protects the public. The whole purpose is to protect the public from those closed-door conversations during the decision-making process. And it provides a right of access to these governmental meetings. Now, it applies when 2 or more members of a governing body discuss matters that may foreseeably come before that body. Okay? 2 or more members, something that may foreseeably come before that body. So when a governing body delegates some portion of its decision-making authority to a committee or a group and basically creates this alter ego, that means that that new body is also subject to the Sunshine Law, which is why I'm talking with you about it now. And I'm going to look at this because I'm too short to see the bottom of the screen in front of me. So what are the 3 fundamental requirements related to Sunshine? Reasonable notice of the meetings. You guys really don't have to worry about that. That's staff's responsibility to ensure that the public is well aware of when you are going to be holding your public meetings. They have to be allowed to attend, the public. It's accessible to everyone, which is why you find yourself now in the library instead of, I think, traditionally, historically, we had these meetings in chambers, but this group is too big. And we needed to make sure that not only did you all fit, but any members of the public who want to attend, also, there's room for them as well. And they have an opportunity to be heard. So there is a public comment portion on every agenda for every single one of your meetings, and that is a state law requirement. Written minutes have to be taken and made available promptly. So in your future agendas, you'll be going through that administrative process of reviewing your minutes and approving those, and they are then filed with the clerk to the board so that if someone wants those minutes in the future, they're accessible to the public as well. Now, keep in mind, minutes can be summary. They have to capture at least the votes that are taken. They don't have to be exhaustive. They don't have to cover every remark made by every single committee member, okay? So, it allows the public to observe each preliminary step leading to the final decision, okay? And it prevents the governing body from creating closed committees that narrow the board's decisions, okay? Now, what happens if you violate it? So it's different if it's a knowing violation versus an inadvertent violation. A knowing violation is a crime. It's a second-degree misdemeanor, which means the penalty is imprisonment not to exceed 60 days and or a fine up to $500. And it can result in removal from the position. Now, I would say that these aren't common prosecutions, but they do occur. So please be mindful and take this legal requirement seriously. It is a requirement for a reason. Even if it's inadvertent, it is a non-criminal infraction, but you can be subject to a fine of not to exceed $500, and reasonable attorney's fees can be assessed. Now, if you rely on my opinion and there's an inadvertent violation of the Sunshine Law, then the collegial body pays the attorney's fees. But if you didn't rely on me and my advice and you violate, even if it's inadvertent, you pay for the reasonable attorney's fees, okay? And it can be filed against an individual. Well, we can go after an individual if someone asserts that there's been a Sunshine Law violation, but it was frivolous or made in bad faith. Hopefully, we don't have that happen either. So civil actions. Basically, it's a default that a violation does constitute an irreparable public injury. So a court can enjoin any future violations if requested by the party who is asserting the Sunshine Law violation occurred. Practically speaking, it would apply and render null and void any action that was taken outside of the sunshine, okay? So you might have to do a do-over, and you have to completely engage in a full discussion, debate, and vote all over again about whatever matter was decided outside of the sunshine, okay? So what do you do if you think maybe a violation occurred but you're not sure? Contact me, please, because under the law, you can cure a Sunshine Law violation, okay? But what that means is it goes on an agenda, you have an open discussion and debate, you have to take a vote if that was part of the discussion outside the sunshine, if there was some sort of formal action, you have to go through that process all over again. But it would be better to cure it than for it not to be addressed up front. Not what anybody would want, but please contact me if you think there might be a problem, okay? So, to make this a little interactive, is an audio recording of a meeting sufficient for Sunshine Law purposes? Anyone? Come on. Anyone? No. Why? An audio recording are not written minutes. Minutes have to be retained in writing. So an audio recording, it's nice to have a backup, but it is not sufficient to satisfy the Sunshine Law. So can a CCRC member talk with the Board of County Commissioner who appointed them to the committee?
Yes.
Yes. Why? Because you're not on the same collegial body, okay? May a CCR member talk with the Board of County Commissioner who appointed them about how another CCR member plans to vote on an issue? No. Why? Because basically you'd be trying to do indirectly what you can't do directly. You cannot serve as a conduit and use somebody else to communicate with another member of this board about something that may foreseeably come before this body. Okay? Can you talk with CCR members about Blueprint, county, or city business? It depends, right? Is it something that could foreseeably come back before this body, even if it relates to Blueprint, county, or city business? You need to engage in that analysis before you talk to another member of this body about Blueprint, city, or county business. This is where it can get sticky. If you think it might, and you're not sure if you can, please call me. I will talk you through that, okay? Is a verbal conversation with another CCR member about a matter to come before the CCRC okay as long as there's nothing in writing about it? No, it does not matter the method of communication. It doesn't matter if it's on the phone, text, email, note, whatever. You just can't do it, okay? Is an administrative issue like scheduling something that needs to be discussed during the public meeting? Yes. In an abundance of caution, yes. Even though that's not a substantive matter, you might have to come back and vote on holding like a special meeting, for example, okay? There was a decision that came out of the first DCA involving Department of Revenue that came out in the middle of a huge procurement while I was at DFS. And they were going through the competitive bid process. They'd had multiple meetings. Everything was done according to, at that time, what we thought was required under the Sunshine Law. Everything was recorded. They would then like stop the recording and go, okay, when are we going to meet again? And they would talk through just administrative logistics, something that really they were like, this is not a big deal. Well, that opinion came out and made it clear it doesn't matter if it's administrative or not. So guess what DFS did? We went back and we cured, because we didn't want somebody to be able to use that as an opportunity to use in a bid protest or assert there was some Sunshine Law violation that occurred. So we just had to go back and redo all of it, okay? That's what I'm talking about when I mean a cure. And sometimes you have to do that, okay? Is appearing on TV for an interview to respond to a position taken by another CCRC member about a CCRC issue in an op-ed piece a violation? And if there is a violation, who violated? I'll give you a minute to think about it. It's a two-part question.
No. No.
Yes, potentially,
Really?
and both of you would have violated. And the reason is this. You can't use the paper as a conduit, just like you can't use an individual to talk to another CCR member about something that could foreseeably come before this body. Now, the nuance there, right? So someone takes a position about X issue. You get a call from a reporter and they're like, hey, would you care to comment on what Mr. Wilcox said at the meeting, what his position is on X? You can go, well, I can't really speak to that. I'll address that in the next meeting. But hey, by the way, I would really like to talk with you about my position on Y. That's totally fine, because you're not directly engaging and responding to a position taken by another CCR member outside of a noticed public meeting, okay? So please be careful about that. If a member of the CCRC sends a memo to the other members taking a position on an issue to come before the CCRC, is that a violation?
No.
No, because it's a one-way communication. To violate the Sunshine Law, it takes two, okay? I'm not recommending you do this, okay? Why? Because if somebody's not thinking and they respond to it, you have a Sunshine Law violation, okay? So just be careful, be thoughtful, okay? And again, if you think something might be a problem and you think about it before you do something, please feel free to call me if you're thinking about doing it. If something happens after the fact, please call me about it, because we can figure out if there really is an issue and I can give you advice on whether you should cure it, okay? So,
Counselor,
yes.
I mean, can we ask a question on your question and answer? My question is, can a county commissioner, he or she meet with their members of the CCRC altogether?
No.
Okay.
Absolutely not. One-on-one, sure, but that county commissioner cannot discuss with the other CCR members any conversation they have with the other appointees about anything that may foreseeably come before the CCRC.
For example, I mean, let's just say a commissioner has a viewpoint that they want expressed here at the Charter Review Committee. So you're saying to me that they cannot get with all three of their appointees to express what their viewpoint is. They can individually, but not collectively. Is that correct?
There can be a one-way communication, but none of the CCR members can respond to whatever that opinion is that the commissioner provides in front of each other, okay? I would also say that sometimes it doesn't require a violation of the law for there to be a perception that the law was violated, okay? So the members of this committee can talk to each other about anything you want, as long as it's not a matter that could foreseeably come before this committee. But what I will tell you is, if you're out in a public place, you're having lunch, Ms. Ellis sees Mr. Wilcox, walks over, and they start chatting, and there's a member of the public there who knows that you both serve on the CCRC, what do you think that citizen might think? That you're talking about something that's CCRC related. Are you? I would assume not. But again, sometimes perception is reality. So if a commissioner meets with all three of that commissioner's CCRC appointees at the same time, and they are observed doing that, there will be an inference, if anybody observes that they communicated about things that are foreseeably going to come before this body. So I would caution against that to avoid even the perception the perception of a violation. Because really, the commissioner can do that individually. There's no need to have them discuss that collectively, is what I would say. Okay? Any other questions on that? Okay. Hi.
So a clarification on that interview, with, let's say, the press, TV, or whatever.
Sure.
And so you give your opinion on an issue that is before. And for it to be a sunshine violation, it requires the other person to respond. But in a way, aren't you now communicating with potentially all the other members of the committee about what your position is on that committee?
Sure. So the one-way communication where you express your opinion is not in and of itself a sunshine law violation. A lot of people confuse that. Again, it takes two, right? But to your point, if someone responds, another member of this committee responds to that, yeah, you're basically opening it up and assuming that all of you read or someone doesn't forward it to you or whatever, then yes, it's become even a bigger sunshine law violation. But the two who violate are the ones who are in trouble. Okay?
Madam Attorney, you're basically saying I can start a text message thing with everybody on it and I can send a message to say, hey.
This is my position on XYV.
Just let
Yes, but I'm so sorry. Please don't do that, though. Please do not do that. Please don't.
I think we started it already.
Somebody needs to kill it, like remove yourself from that text string.
But text messaging, you don't mind that, talk about that communication.
Yeah, so again, this communication that would violate the sunshine law, it is anything that happens outside of these meetings. So again, the medium doesn't matter. Text message, phone call. I'm not on social media, but Snapchat, Facebook, we'll go over social media in a little bit too. I mean, anything, verbal, anything like that. Anything like that, any medium of communication would be a violation. Mr. Ray?
If someone responds to a one-way communication, who has violated?
Both.
Both, right?
Yeah, which is why I wouldn't recommend that you send your one-way communication expressing your views, because you might not have initially violated, but if somebody else responds, you're both in trouble. It's not just the second person, it's both of you.
I see, thank you.
Yeah. Any other questions?
So, Counselor, I just have to bring up this point. On the very last one, you said if you send a memo, and I just happen to work for a body that, some individuals have done that.
It's happened. Yes, I know.
And some have done it more than once.
Yes, I'm aware. Yes.
No, they're gone now, the ones that have done it. But, well, yeah. But, so there was no violation because first of all, they put at the top, they say, hey, do not respond to this email or whatever, maybe a violation, whatever. And then they send out whatever it is and say what they have to say. I don't remember if anybody has responded, but I know they have sent it out. And you're saying that is appropriate, but as long as you do not respond to that, is that correct?
A one-way
Why do
violation?
you recommend not to do it?
I recommend not to do it because while a one-way communication is not a violation, you open yourself up to the risk that someone who isn't thinking about it will respond, and then you have a violation that you have to cure. In fact, it's a matter of public record. It's happened once on a blueprint matter, and they had to go back and cure it in a blueprint meeting because someone expressed their opinion about something that was going to come before blueprint in writing, and without thinking about it, somebody else literally issued a letter responding to it. Boom, done, sunshine law violation, got to cure it. It can happen. I've literally seen it happen. Okay? All right, public records. So it protects the right of access to records made or received in connection with the official business of a public body. Now, what are the component parts? It has to be a record. A verbal communication is not a record, and we'll get more into that in a little bit. Made or received. Note, possession is not required. A record verbally shared or reviewed is sufficient to satisfy this made or received component. And we'll get into that a little bit more. In connection with official business, we'll get into that too. But a request, when it's made, must be acknowledged and a response provided within a reasonable period of time. Under the law, that's all depends. If someone makes a public records request and it's 1,000 records, it's necessarily going to take you longer to produce that than a single email, okay? So, what is a record? Almost anything. It's just not a verbal communication, but other than a verbal communication, the assumption is it is a record, all right? Does it include a CCR member's social media post about CCR business? Yes, it does. Does it include a CCR member's meeting notes? Maybe. Here's why. So your personal notes are not subject to the public records law. Why? Because they're your personal notes. But if you use them to communicate, perpetuate, or formalize knowledge, then they no longer are your personal notes because you're using them to memorialize, communicate, or perpetuate knowledge. So if you like to take handwritten notes and then you go back and you type them up and you put them in your file and you keep them, that's not your personal note anymore, okay? You plan to perpetuate that knowledge. If you have notes from a previous meeting and the issue comes up and you're debating it and you want to go back and you're reviewing your notes and reading from them in the meeting, you've now shared that note. That is now a public record. Okay? So don't interpret what I said about personal notes too broadly because it's very narrow. Okay? But if you have questions about it, let me know and we can talk about it. Does it include text messages about CCR business? Yes, it does. Is a request for information a public records request? No. Here's why. Because a request for information does not relate to a record, okay? So if someone approaches you and they say, hey, when's your next meeting? That's not a public records request. They didn't ask for a record. They just asked when your next meeting is, okay? If they say, hey, do you have a schedule of your CCRC meetings? That's a public records request. And then you have to figure out, does that public record exist? And if it does, we have to produce it, okay? Is that clear difference there? Okay. Are you required to create a record that does not exist? No. And please don't do that, okay? Is a request to inspect records a public records request? Yes. Someone can just say, hey, I'm not sure if I actually want all of these records, but I want the chance to look at them so I can decide if I want a copy of all these records, okay? So, what are your obligations? You have to maintain and retain your public records, okay? So if some constituent emails you about a matter that's going to come up for discussion and debate and vote, That's a public record subject to the public records law. It came to you. No one else has it. If we get a public records request for that record, you have to maintain it and produce it. If we send out that communication saying, hey, do you have any records related to XYZ? If it's within the scope of that request, we have to produce it, okay? Which means you have to retain it. You are the custodian of that record. Now, when don't you have to retain it? If you want to give it to county staff so that the county already has it, then you don't have to retain it because you've given it to the county, okay? And we can produce it if somebody asks for it without you having to help facilitate that, okay? So it counts for voicemails, notes, emails, texts, unless you forward them to staff. Now, text messages. What is your setting on your phone for text messages? Do you know like how long your phone retains text messages? Have you ever looked? Well, depending on the type of record, which dictates the retention schedule, whatever record is created is going to last longer than the work of this committee. And you can't just start deleting text messages. You've got to retain them until that retention schedule is met. Okay? So don't start throwing away your stuff, at the end of a meeting or at the end of your business here. Again, you always have the option of giving all of those records to the county, and you can make it our problem, and then we've got to retain them for you. We basically become the custodian. But please be mindful, you have to maintain and retain those records that are solely in your possession until the retention schedule ends.
Many of us, our phones, for storage reasons, purge every 15 days.
And if that's the case, you need to affirmatively ensure that you are forwarding those records to the county staff or otherwise saving them in a different medium so that you can produce them if they're requested. Okay? I understand that there are limits to technology and space and things like that, but the public records law does not care. Okay? And if we end up getting sued, that's not going to be an excuse a judge is going to accept. Okay? So, who can make a public records request? I led with all the answers, so you guys can just read it. Anybody can. Can you ask them why they want it? No, you cannot. Can you ask them to make it in writing? No, you cannot. They can make a verbal public records request. What do you do if someone makes a public records request to you? If it's in writing, just forward it to staff and we'll take care of it. We may have to work with you depending on the scope to get records you might have or confirm whether or not you have them, but then you've kind of let staff take care of that. In fact, I would recommend that you do that so that you're not responsible for public records requests and we know what's coming in and out because we may get more than one of the same public records requests, okay? And we want to ensure we are being very consistent and producing everything that's requested every single time, okay? Can you ignore? This is an easy one. No, we can't. If you get a verbal request, just tell the requester, hey, thank you. I'm going to forward this to staff and staff will get back to you. And then email the information to staff, okay? Just the basics. Now, some people don't want to give you their name, and that's fine. They don't have to give you a name. All we need is some way to communicate with the requester to facilitate getting the records to them. So they may be like, I don't want to give you my name. Here's my email address. These are the records I want. Send me what you have. Okay, and that's totally fine. Should you try to redact any records? No. Okay. One, because you can only redact public records before they're produced if a statutory exemption applies. Now, you might not like information in a record, but you don't get to decide what you get to redact and you don't. And when we produce a redacted record, we have to cite to the statute as the basis for that exemption. So we have to tell the requester why we're not producing the entire record they requested. Okay? So please don't redact your records. The other reason we need it unredacted is if we get sued, the court has to hold an in-camera hearing or an inspection, basically, a hearing, where the court looks at it and decides whether we should have produced the record in whole or in part. And they are going to need an unredacted version of the record to review. Okay? So don't try to redact records, just let us do that for you. Let me ask a question. So let's say you're bored or you're mad or whatever, and you text with somebody during one of these meetings over an issue that's hotly debated, and you say something unflattering about a fellow committee member. Okay? Is that a public record? Yes. Do you get to not produce it because, ooh, I really, in the heat of the moment, said something unflattering that I wish I hadn't said? You don't get to not produce that. That is a public record. So the other thing I would say is be really careful what you put in writing because it very well could end up in the paper. Okay? All right, so what are the remedies? You know, I put this voluntary mediation program on the slide. I have never heard of anybody actually taking advantage of it, but apparently it is available through the Office of the Attorney General as an alternative dispute mechanism when there's a public records dispute. Usually, someone just sues us because they've been denied the right to inspect or the right to records. And a court can issue a writ of mandamus to compel the official body to comply with the public records law. And they can issue an injunction to prevent the body from violating the public records law in the future. Again, they also get reasonable costs of enforcement, including reasonable attorney's fees. Now, for them to get this, though, they have to give us at least 5 days' notice in advance. So we get a chance to basically produce, like a last chance, if you will, to produce before, if they sue us, they get attorney's fees for a public records violation. All right? So criminal penalties, again, I like this because it makes people take it seriously, I think. A knowing violation, again, is a crime. First degree this time, though, punishable by possible 1 year in prison or $1,000 fine or both. And it subjects somebody to suspension, removal, or impeachment. For this body, it would be removal. And it can, for inadvertent violations, it can also be a non-criminal infraction punishable by fine not to exceed $500. And these are prosecuted by the state attorney's office, by the way. Okay? So, any questions about public records law? I know I'm going fast. You can always contact me after if you have specific questions. Okay? So, Code of Ethics. It protects against conflicts of interest and establishes the standards of conduct of elected officials, in your case appointed officials, and government employees where conflicts can exist, and they do arise sometimes. It applies to board-appointed committee members, as I said, and it just prohibits certain actions and conduct, and it requires disclosure to the public in certain circumstances related to some conflicts. So, under the statutes, different categories. Soliciting or accepting gifts. I think this should be fairly self-explanatory. But if you accept anything of value, and it is a broad definition of value, anything of value, based on the understanding that's going to influence your vote, your action, or your judgment, then that's a violation. Okay? When you can't do business with your own agency, I don't see that this is going to be such an issue for this body, but it is in the standards. Okay? And then you can't engage in conflicting employment or contractual relationships either. Again, I don't think that's going to be as much of an issue for the work of this committee, but it is part of the standards, so I'm going over it now. The last two are waivable, not by you, but by the Board of County Commissioners. Okay? Accepting unauthorized compensation. So again, neither you nor your spouse or minor child can at any time accept any compensation payment, anything of value, when you know with the exercise of reasonable care, should know that it was given to influence your vote or other action. So, related to the CCRC business, to be clear, okay? You can't misuse your public position So you can't corruptly use or attempt to use your position or your property or resources, which may be within your trust, or perform these duties to secure a special privilege, benefit, or exemption for yourself or somebody else. Okay? And then the final one is disclosing or using certain information. So again, this is pretty limited. I don't think really there should be that much of an issue with this one, but you cannot, and this applies to you even after you leave your work here on the CCRC, you cannot disclose or use information not available to members of the public and gained by reason of your position on this body for your personal gain or for the benefit or personal gain of any other person or business entity. Okay? So specific to voting conflicts. So you can't vote on any measure that would inure to the special gain or loss. It doesn't apply to just gains. It can be losses too of you, any principal or entity by whom you are retained, other than an agency, or the parent organization or subsidiary of a corporate principal by which the member is retained. That's the second category. Or that would inure to the special private gain or loss of any relative or business associate of yours. And this relative definition, there are a couple in the Code of Ethics. This one is really broad, okay? So, since you're an appointed body, the rules are a little different from if you were elected, right? Since this is an appointed body, if you don't plan to participate in the matter, what does that mean? It means any attempt to influence the decision by oral or written communication, whether made by you or at your direction, okay? So if you don't plan to participate in a matter for which you have a voting conflict, then the procedure is you make an oral declaration of the nature of the conflict, you abstain from voting, and then you file what's called a Form 8B, memorandum of voting conflict with the county's clerk within 15 days of the vote being taken. Okay? It's different though if you, I have does not on both of these, don't I? Sorry. This second one is when you do plan to participate.
It says does.
Oh, okay, great. Does intend. Yes, sorry, I misread that myself. I was like, I thought I got that right. Okay, so if you do intend to participate, then the process is a little different and it's more of a timing issue, okay? If you do intend to participate, then you file the memorandum of voting conflict prior to the meeting, okay? And the memo is provided to the other members and it's read into the record publicly at the next meeting after the memo is filed. Now, you can do that, or you can make the disclosure orally at the meeting before participating, and then you start to file the Form 8B, Memorandum of Voting Conflict with the clerk within 15 days after the oral disclosure, but then it's also immediately provided to the other members and read at the next meeting, and then filed by the clerk. Okay? So you can always refer back to that if this comes up. If you wonder if you have a voting conflict at all, then let's talk about it. Call me. And I can talk you through that so that you know. Yes.
With the exception of recommendations relative to elections, does that mean that electeds or potential candidates would have a conflict if there were to be recommendations made relative to elections or processes associated with elections?
I would need to research that. I know that there's an exception for members of collegiate bodies to vote on matters like salaries, like their salaries. They can obviously vote on that, otherwise they could never act as a body to address that sort of an issue, but I would need to research that.
Because based upon the recommendations that have come from previous charter committees, right? That there are persons who were, say, for example, on this, everyone here was a candidate for the city and I'm with the school board, but outside of that, any recommendations would not have any inured potential conflict for any of us, I can't imagine.
Yeah, it's always a case-by-case analysis. So what we're going to have to do is, as potential issues come up for debate and potential voting, We're going to have to analyze those on a case-by-case basis depending on your current situation, whether you're a sitting official, whether you're a candidate, or whether you have some other role, informal or formal, okay? So it's going to really be a case-by-case analysis that we're going to have to analyze every single time, okay?
Man.
Yeah, hi.
On the previous page, the word agency, what is captured by the agency? Would that, for instance, be the city, school board?
It's not going to be either of those. It certainly is the CCRC. It could be the county. But again, it's going to really kind of depend to some extent on the particular individual and the particular issue upon which the body's going to be voting. So again, it's going to be like a case by case.
Thank you.
Yeah. Any other questions? Okay. All right. So final thought here, and this is a slide that I'm starting to just now put in my presentations, and it's not public records, it's not sunshine, it's not ethics, but it is important. I'm not really like in social media, but some people love it. I actually really am glad that I don't really talk with the press. Some people love it. And there's going to be a lot of interest in the work of this committee. So you're going to get requests for your positions and comments and how you feel about things. I would note, there's a clause in the bylaws that says the chairperson is tasked with representing the committee at all functions and activities. But even the chair does not have authority to state any position of committee not previously approved, okay? You also all have your First Amendment rights to free speech, okay? But those are not unlimited, okay? Please keep in mind that, again, those rights are expansive. If it ever becomes an issue and the Board of County Commissioner wants to remove you for some public statement or position or whatever you've taken, your First Amendment right to free speech may or may not protect you from that removal. Okay, there's a whole line of case law under the 11th Circuit. It's very well settled, binding precedent in this jurisdiction, okay? And it's analyzed as if you were a public employee. You're not a public employee, but that's the analysis that the court uses, and it's generally called the Pickering analysis. It's very fact-specific in every case. If you want to talk with me more about that, I'm happy to do so. I can tell you what those citations are, and you can go read the cases yourselves, okay? So just something to be mindful of, and I want you to have that information on the front end, okay? All right. Any other questions?
One, and you didn't mention it, so I'm believing that it doesn't apply. Is there any requirement for financial disclosures or anything as part of this committee?
It is not, no. No financial disclosures. Yeah, yeah.
I didn't see these slides in our binder. You're gonna,
We can release those to you, sure.
please, thank you.
Yeah. Anything else? All right. Please call me. I'm a resource for you. Yes.
I noticed that you mentioned in your last slide about the chair.
Mm-hmm.
Will we be electing, are we electing a chair for this body today?
I believe Vince is going to cover that later in your agenda. Mm-hmm. Okay. Thank you, everybody.
All right, folks. So as you've probably seen by now, we've provided each of you with a committee binder that is full of resources to help you review the county charter over the next few months. Under tab 3, you will find your bylaws as provided by the board to assist you in this process. I know we've covered a lot today, so I'll just hit on some of the most important components just to get you started. But we're always here to answer any questions that you have. I can't emphasize enough, we are a resource to help you in your work. So starting off with quorum requirements, before the committee can take action on anything, they must have a quorum. This will be a majority of the committee's membership, so 11 members, they must be present. If you're unable to attend a meeting, just give us a heads up so that way we're able to ensure that we'll have a quorum for the upcoming meeting. Once a quorum is established, the committee will follow Robert's Rules of Orders. If you need a refresher on those, we've provided a little cheat sheet under tab 4 of your binder. Tab 4, as you'll see, also provides a voting thresholds cheat sheet, just as a quick glance guide to the committee's to help guide the committee's motions and required votes through your work. Also, each of the committee meetings will provide an opportunity for public comment where citizens will have a few minutes to speak on matters before the committee. We'll have that segment later today, but just a couple reminders. This is an opportunity for you all to receive community input. However, public comment does not mean public dialogue. And what I mean by that is public comment is one-way communication that the committee can take into account when making decisions, but it does not require you to respond or take any action in the moment. Citizens may also submit written comments to the committee, which will be compiled and provided to the committee for its review in advance of each of its meetings. Finally, one of the first actions of the committee will be electing its chair and vice chair. The chair will have a critical role in leading meetings and keeping your decision-making process on track and in proper order. With this in mind, I did want to take an opportunity to open it up to you all. If anyone would like to make a potential nomination for a chair. Yeah, go ahead.
Well, I think in lieu of what you've described, I think experience in the charter review process, I think is important to me, particularly with this being, is that better? Particularly with this being, for many of us, our first time serving on this committee. Others may have been here before. And I think someone who's also been a part of the charter review process, particularly when I look at this audience and I look at those who are currently serving, and I'm looking at a great community servant at the end of the table, Commissioner Mary Ann Lindley, who was a commissioner when we last had our charter review committee process. And I think she would make a great chair. So this is where I make the nomination. I'd like to nominate Commissioner Mary Ann Lindley.
Second.
Okay. All right. This will normally be handled by the chair going forward, but to help facilitate this right now, we will call a vote for Ms. Mary Ann Lindley as chair. All those in favor, please say aye.
Aye.
Any in opposition? All right, I guess we have a new chair.
She might oppose.
Yes,
Well, thank you. I'm completely shocked. Thank you.
Right.
I appreciate it. Yeah. Looking forward. Do I just take over for now? Carry
I mean,
on.
if you wanna call a vote for, or nominations for the vice chair, I'd love to hand it over.
Sorry, yeah, let me get my head together for a minute. Well, I guess that's exactly what we need to do next is, do I hear any motions for vice chair of the committee? Yes, may I hear, yeah, excuse me.
I'd like to nominate Chauncey Haynes.
Chauncey Haynes has been nominated. Do I hear a second?
Second.
Second. Are there any other nominations? Okay, without further ado, all in favor of Chauncey Haynes as our vice chair of the committee, please say aye.
Aye.
Those opposed? Chauncey, congratulations, you're our vice chair. Thank you.
Just want to clarify who the second was on that.
Jay Terry.
Jay Terry. Mhm.
Well, congratulations. So with that foundation, I know it's very quick. Again, if you have any questions, we're here. But now I'll hand it over to Ken Morris to provide a look ahead at your process, as well as your schedule for the upcoming weeks ahead.
All right, time's running short. I'll run through these real quick, 2 quick slides. Both of them are cheat sheets in your binder. The first is tab 5 in your binder. This just covers a little bit about how the process is going to work for the committee. How do you really get started, starting at the next meeting? And this is all based on the bylaws, this one-page cheat sheet. It's intended to provide you
a guide on the deliberate purpose for each meeting. We promise the next meeting won't be as presentation heavy. A lot of things we had to cover today as part of the orientation, but going forward, you'll have three types of meeting. They're sequential. First, you'll have issues and discussion items. This is where you're gathering information. You may request more information about how a county service or function is provided. We can bring in department directors in. If that's helpful, we can provide the committee written information. All of this is done just with a simple majority vote of the committee. As the committee starts to hone in a little bit on where they want to go, what they want to do, and start talking about potential amendments, again, request a full analysis. We'll bring it back to you. Here's the lay of the land. Here's what you could do, can't do. You may want to know where the county might be preempted by state law. Chastity covered some of those things. Vince covered some of those things. You may want to understand where we may have a conflict with the city or not, where we're allowed to push the charter provisions. We can bring all that back to you in the written analysis. Again, in most circumstances, if the committee wants to advance an issue, it's going to require a simple majority vote. The only time where we move up to the 2/3 majority vote is if you want to go back in the process. So when you get to your decision-making meetings, that's where you're looking at draft language for an amendment. And in those meetings, you can approve it, you can, deny it, you can amend it, manage it, however you want. This is ultimately going to be your product. But once you reach those decision meetings, if at that point you want to introduce a new issue or bring back an old issue, that's when we say that's going to be a 2/3 majority vote, because again, we've moved on to different types of meetings. The next slide lays out a schedule for you. We've got 9 meetings total, including today. We may need all of them. We may get done early. The last Charter Review Committee finished all their regular meetings in 6 meetings plus 3 public hearings. No pressure on you guys. We're here to support what the committee needs. After the scheduled February 19th meeting, we'll provide an interim report to the County Commission in March. And then from there, we'll be able to establish what our official meeting dates are for the public hearings, assuming you have recommendations for the charter. Those meetings would be in the summertime, sometime in June and July. There's specific requirements about how far apart, but not too far apart, those meetings can be. But we'll cover that later on. So again, we would anticipate you to finish up by February 19th or sooner. You see, we have scheduled out here what we anticipate being the issue and discussion meetings. But if by the 4th meeting you want to jump in a decision, you're ready for it, again, that's the will of the committee. We're here to support you and ultimately your recommendations back to the County Commission. Thank you. Let me know if you have any questions about bylaws before we move on.
A question: if a person's out of the country and the ability to use Zoom, is that something that the commission takes up themselves, or is it established?
The bylaws require in-person participation.
Quick question. You said the last county charter review finished in 3 meetings, that we said?
6 regular meetings plus their 3 public hearings. You've got 9 regular meetings scheduled, including today.
I was just trying to see what the precedent.
No pressure. Yes, sir.
The bylaws can be amended with the 2/3 vote of the committee?
Yes.
Well, also, if a person is missing, they can listen in on Zoom, but cannot vote or participate or be counted as part of the quorum, correct?
That is correct.
I mean, there's no objection to that, but they have no role in terms of asking questions or participating.
They're not counted for attendance purposes, and I would just clarify, they can listen online. It wouldn't be a Zoom
Okay.
participation. It would just be on TV, online, like
Just like a
member of the
regular
public.
citizen.
All right.
All right. Again, any questions along the way, just reach out. We're happy to help. So the last segment of our agenda today is public comment. As noted previously, speakers will have 3 minutes during this segment to provide comments to the committee. Just going ahead and explain the routine process for this. We'll call speakers in the order in which their speaker cards are received. However, I don't believe we have had any speaker card submissions today. So we'll keep moving along. What? Unless there is anybody in the audience that would like to provide comment? All right. So as a closing reminder, your next meeting will be on Thursday, November 6th. At that time, we'll provide a brief overview of Leon County government as well as the government structure as set forth in the county charter. We'll present the board's proposal for the committee's consideration and have an opportunity for initial deliberation among the committee for discussion. So with that in mind, thank you again to each and every one of you for your time today. If any questions come up between now and your next meeting, we're available. Please don't hesitate to reach out, and we look forward to seeing you in a couple weeks. And I would now like to hand it over to our new chair for closing comments and adjournment.
Well, the only comment is thank you very much for your trust in me. I hope to be a good spokesperson for our committee. Look forward to working with you all and getting to know some of you better too. At that point, if we're ready to adjourn, do I hear a motion to adjourn? Second? Okay, without objection, we're adjourned. Thank you very much.